Today I want to talk about a recent case we had where our client had been deported to El Salvador not once, but twice, and we managed to get her green card. In this case, the client had entered the United States illegally, and on the second occasion, she married a United States citizen. She was subject to domestic violence, and the marriage did not go well. Because she was subject to an expedited removal order, she was deported while she was pregnant on the second occasion. It's important to know that an expedited removal order has two important things that one should know about. You're not allowed to see an immigration judge. And two, within 14 days of encountering you, ICE could deport you. After getting deported back to El Salvador and giving birth to their child, her husband went to visit her in El Salvador. Unfortunately, he kidnapped their kid and came back into the United States, knowing that she was subject to something called the permanent bar, where technically she was not allowed to the country forever, and she would have to wait even 10 years to seek admission to the United States. Because the client was subject to domestic violence, she was eligible for something called VAWA. VAWA relief comes from the Violence Against Women's Act, where victims of domestic violence have an avenue for immigration relief. Although the client was eligible for VAWA relief, she did not obtain a great result from her previous attorney. When she came to us, we were able to reassess her case, not only in the context of her VAWA relief, but all the complexities that were surrounding her case: the expedited removal order and the permanent bar. Under the Immigration and Nationality Act, we did find a way where this exception for the permanent bar applied if we were able to connect that her third attempt in coming to the United States was connected to the domestic violence, which, given the kidnapping, we were able to prove that. Today she's a green card holder and her expedited removal order was not reinstated.